American Express, investigated by the U.S. government, caught processing a Soviet-era politician's dirty money, paid hundreds of millions in fines for deceiving customers. Rather than clean up their act, American Express has gone woke. Employees say people are promoted and told to offer lower premiums based on race. Amex administered critical race theory training that told employees capitalism is racist. American Express. Serve your customers, not woke politicians. Visit unamericanexpress.com.
This message was paid for by Consumers Research, a 501c3 educational advocacy group. To learn more, log on to consumersresearch.org.
You're listening to Underground USA.
Several of these conservative justices, who are in no way accountable to the American people, have lied to the U.S. Senate, ripped up the Constitution, and defiled both precedent and the Supreme Court's reputation, all at the expense of tens of millions of women who could soon be stripped of their bodily autonomy.
Before we get into the meat of this issue, it's important to understand that a draft opinion is not a ruling. It's a precursor to a ruling, a moment in time when the U.S. Supreme Court justices make their cases to the other justices on why they hold the preliminary decisions they do. Roe v. Wade has not, as of this recording, been overturned. That said, the chances are significant that the long-standing privacy decision that protected abortion access will be overturned, according to the now verified draft opinion and the direction in which it points, and that the right to determine the legality of and the restrictions, if any, applied to abortion would return to the individual states. You're listening to Underground USA. In what was supposed to be a privately held, internal draft opinion penned by Supreme Court Justice Samuel Alito, it is preliminarily inferred that the U.S. Supreme Court is leaning towards striking down Roe as an overreach of the federal government's authority under the U.S. Constitution. The decision would remand the regulation of abortion to the states, not make the procedure illegal. In the draft opinion, Justice Alito writes for the majority, Roe was egregiously wrong from the start. We hold that Roe and Casey must be overruled. It's time to heed the Constitution and return the issue of abortion to the people's elected representatives. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human person comes into being at conception, and that abortion ends an innocent life. Others feel, just as strongly, that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others, in a third group, think that abortions should be allowed under some but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. The Supreme Court has confirmed the authenticity of the document, but protested that the leak constitutes an unprecedented breach of protocol and will be investigated, as well it should. The decision is not final, deliberations are still taking place, and the process has been bastardized for political purposes. Roe v. Wade did not legalize abortion, nor did the ensuing Planned Parenthood v. Casey ruling. In the Roe ruling, the Supreme Court held that a woman's access to an abortion fell within the right to privacy protected by the 14th Amendment. In that ruling, it was stated, "The Due Process Clause of the 14th Amendment protects against state action to right to privacy, and a woman's right to choose to have an abortion falls within that right to privacy. A state law that broadly prohibits abortion without respect to the stage of pregnancy or other interests violates that right. Although the state has legitimate interests in protecting the health of pregnant women and the potentiality of human life, the relative weight of each of these interests varies over the course of pregnancy, and the law must account for this variability. This decision relegated abortion to a matter left to the states with certain stipulations. During the first trimester, it is considered a medical procedure and a matter exclusive to the doctor-patient relationship. During the second trimester, states may impose regulations on abortion that are reasonably related to maternal health. And in the third trimester, after the point of fetal viability, a state may regulate abortions or prohibit them entirely, with exceptions to save the life or health of the mother. The case of Planned Parenthood versus Casey reaffirmed Roe and further prohibited states from imposing an undue burden on a woman seeking an abortion. In this decision, undue burden is defined as a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. Under this standard, the only provision specifically excluded in the matter of undue burden was the husband notification requirement. In the end, should the Supreme Court overturn Roe, the total effect of that move is to cede authority, to return authority over the matter to the states. Does anyone who has two brain cells believe that California, Illinois, New York, Washington, Oregon, and a variety of other states are going to place a prohibition on abortion? Even states like Texas, Alabama, and Florida have struck reasonable ground in weighing access to abortions for all. This makes comments made by U.S. Senate Majority Leader Chuck Schumer and House Speaker Nancy Pelosi on the matter of the draft opinion transparently political, opportunistic, and manipulative, even as it showcases their complete constitutional illiteracy.
Last night, a report disclosed that a conservative majority of the United States Supreme Court is ready to overturn Roe v. Wade and uproot decades of precedent affirming a woman's right to an abortion. If this report is accurate, the Supreme Court is poised to inflict the greatest restriction of rights in the past 50 years, not just on women, but on all Americans. Under this decision, our children will have less rights than their parents. The Republican-appointed justices' reported votes to overturn Roe v. Wade will go down as an abomination, one of the worst, most damaging decisions in modern history. Several of these conservative justices, who are in no way accountable to the American people, have lied to the U.S. Senate, ripped up the Constitution, and defiled both precedent and the Supreme Court's reputation, all at the expense of tens of millions of women who could soon be stripped of their bodily autonomy and the constitutional rights they've relied on for over half a century. The party of Lincoln and Eisenhower has now completely devolved into the party of Trump.
No constitutional rights are being stripped, and abortion is not being outlawed. Everyone, everywhere, should be outraged and full-throatedly vocal in their condemnation of the politicizing of this issue. It's purposely dishonest to the core and serves the purpose of fomenting chaos and violence in our urban areas again this summer. The American people should use this moment in time as a litmus test of honesty in the political and media spheres. Those claiming, as Schumer and Pelosi are, that rights are being violated and abortion is being outlawed cannot be trusted to tell the truth. They should be sidelined from influence and government. The fact of the matter is this. The Supreme Court decision to overturn Roe, should that be the case, is a decision centered on the 10th Amendment, relegating anything not specifically enumerated to the federal government in the Constitution to the individual states. The 10th Amendment states clearly, The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Additionally, the intent of the framers is made conclusively in Federalist 45, where James Madison wrote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects, as war, peace, negotiation, and foreign commerce, with which last the power of taxation will, for the most part, be connected. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state." We've been conditioned to believe, and both political parties are guilty of engaging in this deception, that the federal government has purview into every aspect of our daily lives. Under the U.S. Constitution, it does not. It wasn't until the egregious Supreme Court decision in Wickard v. Filburn that the Commerce Clause was redefined to open the door for federal intercedents into anything they chose to involve themselves in. Perhaps, given the Supreme Court's move to revisit Roe, they might do something that would help to save the Republic from the greedy talons of the global elitists who seek to end the great American experiment, placing our nation's people under the rule of totalitarian global governance. Perhaps, just perhaps, they will revisit the Wickard v. Filburn decision and return our federal government to its limited purview as constitutionally mandated. Then, I never thought I would see the day that the Supreme Court would rule to reduce the power of the federal government. So there's that. Please like the episode on the platform you're listening to us on, leave a comment if it lets you, and share us with your friends and family. Our influence grows when you share our podcast. And don't forget to sign up for our Substack, which comes directly to you, subverting the interference of the internet gatekeepers and social media censors. This is going to be increasingly important moving forward given the world's trajectory. You're listening to Underground USA. My name is Frank Salvato. We'll be right back after this.
He calls democracy messy, props up the Chinese Communist Party, praises Xi and his regime, known for violent oppression, invests in Chinese military companies. A defector? No. It's BlackRock CEO Larry Fink, the CEO of a major American company who's gone all in on China. Can he be more anti-American? Larry Fink, BlackRock, taking your money, betting on China.
Message paid for by Consumers Research, an independent educational 501c3 nonprofit organization. Log on to www.consumerresearch.org to learn more.
Did you know that Yaupon is the only tea plant indigenous to the United States? Hi, I'm CJ, the owner of Emerald Coast Tea Company. We have a line of Yaupon teas and Yaupon tea blends that will open your eyes to tea that is literally made in the USA. Check out our entire line of teas at www.emeraldcoastteacompany.com. Honey, this ain't your mama's tea.